And good evening. Thanks for joining us. I'm Richard Gearhart. You're watching a very special edition of KSBY News on Facebook. For the next 30 minutes or so, we will be talking in depth about what's happening in the Kristin Smart murder trial. We're calling this show Beyond the Headlines because we want to take you beyond the daily reporting and dig deeper into some of the issues surrounding this trial. It's a complex case, more than 26 years in the making, and there's a lot to talk about. So this will be our first special with many more to come as the trial takes place over the next few months. And so first we're going to get you up to speed on what's happened so far this week in court. Paul and Ruben Flores are charged in connection with the 1996 disappearance of Cal Poly student Kristin Smart. Paul, who was also a student at the time, is charged with her murder. His father, Ruben, is charged as an accessory, accused of helping her hide the body. Monday was the official first day of the trial. The prosecution presented its opening statements, and Paul's attorney, Robert Sanger, introduced his defense. But Ruben's attorney, Harold Miesig, did not get a chance to present his opening statement until yesterday morning. Court was delayed for 2 days because someone involved in that trial was ill. Once Miesig was able to deliver his opening statement, it was time for testimony to begin. Kristin's mother, Denise Smart, was the first witness called to the stand, followed by her brother and her father. And we intended tonight's show to be live, but we are having some technical difficulties, so we pre-recorded and are coming to you a little later than we promised. Still, we'd like to invite you to share your comments and questions in the chat below. We'll be keeping track of all of them and compiling them for future episodes. And today, I want to take a deeper dive into the jury selection process specifically and the uniqueness of this two-jury system that we have in place for this case. And my guest tonight is Mary Wofford. And first of all, why don't you tell me a little bit about your background?
Good evening, Richard. I was a DA in the Ventura County District Attorney's Office back in 1988. And I left the Ventura DA's office in 1997.
Okay.
And then got a job in the Monterey District Attorney's Office and worked for Monterey District Attorney's Office for 22 years and retired last year. And now working with Jeffrey Stolberg here in San Luis Obispo as a co-counsel on a sexual harassment case.
Perfect. All right. Well, congratulations on your retirement, or at least your semi-retirement, because you're still working.
Yes.
And so you've been through this process before.
Yes.
And so one of the reasons that I wanted to do this show is because I, obviously been sitting in court, and I've covered court cases before. We've covered this case all along. I was working at the station when this happened, so I've, followed this case from the very beginning 26 years ago. But I've been sitting in court, and really there are some things are catching me by surprise. Maybe they shouldn't, but they are, right? And so one of the things is this idea of jury selection. And I was really sitting in court. I was there for part of the jury selection process, and I was sitting in court thinking to myself, this is so important, right? Like the outcome of the case, really the lives of these two defendants are sort of hanging in the hands of these 12 people who are ultimately going to decide each of their fate. And it occurred to me that we should kind of talk about this idea of jury selection. So from an attorney perspective, what goes into jury selection?
Jury selection, and I tell people, is the most important part of a criminal trial, and for that matter, for a civil trial. But in terms of a criminal case, you're dealing with someone's freedom, and that's not to be taken lightly. And I always tell, when I was doing jury trials, I would tell jurors, you're the most important part of this whole process, because without you being involved in the process, we don't have a process. And so, and it is an inconvenience for the jurors because they have to show up. There's delays because there's some issues that come up between the lawyers, and they have to be worked out outside the presence of the jury. So they could be told to come back to court at 9:30, and court may not start until 10, until those issues are worked out. And I know the Flores case, that judge is, we call a working judge, in that she takes care of other matters.
Yeah, she was doing sentencing on last Tuesday when I was in
Right.
Congress, yeah.
So she handles other matters before she starts that jury trial.
Yeah, and when I was sitting there, I was also thinking, from the attorney perspective, watching the attorneys question the potential jurors or talk to the potential jurors, that I always think of law school as being prepared to try these criminal cases, doing the investigations, talking to witnesses, but selecting the jury is a huge part of it as well. How do you learn that part of it?
It's one of these things that you're going to have to use your instincts, you use your investigators, you use your experience, and you just have to stand up talk to the jurors, and if you're, as a prosecutor, as a former prosecutor, you're going in and you're looking for fair and impartial jurors. Because as a prosecutor, you know that your case is, you can prove it beyond a reasonable doubt. And if you don't know that, you shouldn't be standing up and asking 12 jurors to find a defendant guilty. So when you walk into the courtroom, and when I walked into the courtroom, I always felt, what an honor, what a privilege to represent the people of the state of California, and to walk into a courtroom to do what's right and what's just. And you want to communicate that to the jurors during jury selection, that, you know, we're looking for fair and impartial jurors. We believe in this justice system. It's the best justice system that we have in terms of, you know, all 12 of you have to agree that this man is guilty or this woman is guilty. It's not 50% of you, it's all 12 of you. You must reach a unanimous verdict.
And talk first of all about that idea of beyond a reasonable doubt, because when I was listening to some of the jury instructions, that even struck me, right? So the judge said not beyond any doubt, like there's always doubt in life. So what do we mean by reasonable doubt?
Well, the law says that it's an abiding conviction. And what I would say to jurors when I was doing jury trial is reasonable doubt, because you think, oh my God, beyond a reasonable doubt, that's an impossible standard to reach. It's not. It's a standard that's met every day in courtrooms across America. Every day there's criminal trials, and every day jurors are called upon to listen to the evidence and make a decision. And when we talk about reasonable doubt, every crime has elements. And in order for a juror to find a defendant guilty, each and every one of those elements must be proven beyond a reasonable doubt. So what a prosecutor, and I haven't followed the Smart case, I'm sure there was PowerPoint presentation.
Yeah.
And you list your elements, and then you list what you believe the evidence is going to be. So if you can show what the elements to each offense and the evidence, the facts that you believe you're going to be able to prove, you can prove that case beyond a reasonable doubt based upon the facts and the evidence.
And in this case, the evidence, there is no smoking gun. That's what the defense said right away, right? There's no body, there's no smoking gun, there's very little forensic evidence. And so this is really about, and they talked a lot about this during the selection process. They've talked a little bit about it, the judge did with the limited jury instructions given so far, is that this is an inferential case, meaning that you have to sort of infer. She even gave an example to the jury, and she said, you know, direct evidence would be, if somebody swimming in a swimming pool would be, you see them swimming and they get out of the pool, right? But also if you see a person get out of the pool, they have a wet bathing suit, they're wet, there's wet footprints leading to them, you know, beyond the pool, that you can infer that they were obviously in the pool. And so that's what she was talking about in terms of inferential evidence. Is it harder to get juries to get to that reasonable doubt?
Well, I think it depends on the presentation by the prosecutor. It's really going to be important for the prosecutor in a circumstantial evidence case to show the reasonable inference of the evidence. And they'll receive a jury instruction, and I believe it's CalCram 223 or 224, and it talks about, and it outlines circumstantial evidence. And the court will read that instruction, and it depends on how the court decides to handle it. Sometimes the judges will read the jury instruction prior to the attorneys doing closing statements. Sometimes it's after the attorneys have presented their closing statements. But in any event, when the jury retires to the jury room, they'll receive a packet of jury instructions. And they can use all of those instructions, or they can use those instructions that they deem are appropriate for the case and the facts. And so the circumstantial evidence instruction, it can be confusing, but if you have an experienced prosecutor explaining that instruction, it's actually a very good instruction. And the instruction begins, it explains direct evidence, just as the judge explained. You see a person getting out of the pool, you know that that's direct evidence that they were in the pool. But, and then the other examples that the judge gave of the footprints and the wetsuit and the inference that you can make that they were in the pool, if you didn't see them getting out of the pool. And so the law says that circumstantial evidence is just as good as direct evidence. It's just going to be incumbent upon the prosecutor to make sure that those inference and those steps
that the jury can make those connections.
Yeah. And of course the defense is going to come back and say, oh, there's inconsistencies. that instruction goes on and to talk, the circumstantial evidence, it talks about reasonable interpretations. And the law will say that if there's two reasonable interpretations of the evidence in circumstantial evidence, if there's two reasonable interpretations, one pointing to innocent and one pointing to guilt, they must adopt that interpretation pointing to
innocence, right?
To innocence,
yeah, because
and find the defendant not guilty.
So, you know, and I wondered about that, and I wanted to kind of get your take on, you know, how good juries are at that, because there is this presumption of innocence, right? And that's a constitutional guarantee. But, you know, I get this feeling like, you know, if people see defendants being arrested or they see them on television, they know they're charged with crimes, that it's hard for people to sort of remember that presumption of innocence.
I don't think so. You know, the judge will tell them, you know, as the defendant sits there, he's innocent. And I don't know if the judge did this.
No, yeah, she absolutely did. And she said, you know, just because a person's arrested, just because a person charges are brought against them, just because they've been in jail does not make them guilty. Yeah.
Exactly. And from my experience, jurors really believe that. They listen to the evidence, they're attentive. And I don't know if this happened in the jury trial or not. A lot of times, the judges will not give the jurors notepads and pencils until after the opening statements, because the judge will tell the jurors, opening statements are not evidence.
Yeah, you know what she did, which I actually was kind of surprised about too. You know, obviously I've been paying a little closer attention to this case, and we have to travel up there, so I've got to drive up to Salinas, and you know, so I'm there in the courtroom. That's my undivided attention. But she said, you have notebooks and you can't take notes, but I want to point out to you that taking notes can distract you, and I'd rather you not take notes or write them down after the
right. And the thing with this trial, there's a court reporter, so if they needed to have something read back, they can simply send a note to the judge.
Which she also pointed out to them too, yeah.
Oh, okay.
Yeah, exactly.
Okay.
So let's circle back just for a minute before I forget, honestly. What is the actual process? Like, how many jurors, as a prosecutor, can you remove from the panel, if you will? How many can the defense remove? What reasons can you say you don't want the jury on the panel, et cetera?
All right. Now, with in this type of a case, the Flores case, they have 20 preemptory challenges, which means that they can excuse up to 20 people for no reasons whatsoever. Now, there's also, they can challenge jurors for cause. If a juror during jury selection indicates that they're not going to follow the law, that's a challenge for cause. And you just make a note, and when the defense finished speaking with the jurors, you approach, and I don't know how the judge is handling this process. You tell the judge, well, I want to challenge this person for cause, and then there's a discussion between the attorneys and the judge, and the judge will make the final decision as to whether or not it's a challenge for cause.
Well, you know, and actually that's a good, I'm sorry to interrupt you, but that's a good point. You know, they have, and we drew this kind of graphic there, and in between where the jury box is and the judge, there's an exit to the courtroom there, and they actually walk back into the hallway when they're having those conferences. Is that typical? I mean, I've seen them approach the bench before, but they actually leave the room.
Yes, I was a prosecutor in Monterey, and it is typical. And the reason that's done is so that the jurors cannot hear the discussion.
Yeah.
And so even though the judge can turn off the microphone, and it's an important case like this, the Flores case, the judge is not going to make any missteps. She's going to make sure that this case is handled properly. I mean, it's predicted that it's going to take into October.
Yeah, exactly.
And you don't want to make any sort of missteps. So that's very prudent of the judge to bring the attorneys into the back hallway, have that discussion there, and then they'll put it on the record outside the presence of the jurors.
And during those discussions, just out of curiosity, what types of discussions are they? Like when you're talking with the judge, you know, what are you guys talking about? You're talking,
well, it's usually an argument about whether or not it's a challenge for cause. Okay. Because of course with the defense, they want you to use your peremptory challenges.
So you run out of them.
So you run out of them. Yeah. And of course as a prosecutor, you want to excuse anyone that you have a feeling that's showing a bias, a motive, that's not going to be fair and impartial.
So when Chris Purvell, the deputy DA was actually questioning the jurors. He was almost posing questions and then picking an individual juror and saying, how would you answer this question, or asking them how their response to it, if you will. And he was asking questions like that, can you infer from this? One of the things he was talking to the younger jurors about, which brought up a good point, right, is can you put yourself in a time back in 1996 when there weren't cell phones, when you weren't checking in with your mom every, once a day, if not more often, when there wasn't GPS tracking. Is that a reason to excuse a juror? I mean, I know that they weren't excused because I can see the jury, there are some young people on there, but people who are, say, in their 20s don't remember a time when there were no cell phones.
Right, and that was very wise of the DA to do that, because you want to make sure that you have jurors that are, one, going to be intelligent enough to listen to the evidence and understand that, okay, because they may say, even though you're not supposed to bring in what you would do, you're to base your decision on the case based on the evidence that you hear in court. But you want to know, what is the background of that juror? Are they going to be able to set aside their own, what they would have done, and base their decision based on the evidence that's presented in court and nothing else?
So I know I'm kind of jumping all over the place here, but it's kind of fun to talk to an attorney who's been through this process. Are there any types of jurors, or are any certain occupations that you really like to see in a juror? I mean, are you saying, oh, this is a teacher and I like teachers, for instance? Or
it depends. Now, when I was a prosecutor in Monterey, there were certain people I didn't want on my jury. Yeah. And every prosecutor has, and it's not a bias, it's not a prejudice, it's just you just don't want certain people. Sometimes you want more men, sometimes you want more women. It depends on the type of case. If you have a domestic violence case, you're going to want more men. But the bottom line is, you want fair and impartial jurors. You want intelligent jurors. You want jurors who are going to pay attention, and most and foremost, you want jurors with common sense. Yeah. Because a lot of the case comes down to common sense. Look at the evidence. Look at what makes sense. Is there a ring of truth to what the testimony of each of the witnesses? Because you're going to get that jury instruction that deals with credibility of witnesses. And it lists all the things that you can use to judge the credibility of the witness, the manner in which they testify, the knowledge that they have of the event that they were testifying to. Do they have a motive? If there's a bias. All those things are very important in determining the credibility of witnesses. And so the DA questioning the younger jurors, do they have that ability to judge the credibility of the witnesses? It's when you look at what's involved in this case, there's two men that are facing, I don't know if they're looking for the death penalty on the case, or if it's life in prison.
Yeah, I'm not sure about that either, to be honest with you.
Okay.
So, yeah.
And so when you look at it, you're looking at taking the freedom of someone.
I do know that, because it's 25 years to life.
Okay, so it's not a death penalty case, it's a life. You're looking at someone going to prison for 25 years to life. So that's not something to take lightly. And it doesn't matter whether you're in a murder case or a misdemeanor case. When you're taking the freedom of a citizen, it's very important that if you're standing up as a prosecutor and saying this person is guilty, that you believe that that person is guilty.
We're watching video right now of some of the players in the case kind of walking to the courtroom. We're not allowed to take video inside the courtroom while the proceedings are going on. That obviously, as you know, is up to the judge. And she has ruled that there can only be one still photographer who operates as a pool photographer, which means that we can all get the still photos from that person, but we're not allowed to take the jury. But I was also kind of surprised by this, right? So here's Ruben and Susan Flores walking in. He's out on bail. And so he's kind of standing there, and the bailiffs are watching, right? But he's just in the hallway while they're waiting for court, and we've all been instructed that we can't talk to him, and he can't talk to us, and he can't talk to any jurors, which may wonder why. They're obviously assembled in the jury room. But the first day, there were some jurors who, didn't know where to go, and they're everybody's standing around, Is that pretty typical, or is that from a smaller court, county?
The jurors are told not to talk to anyone. And the defendants are told by their lawyers, because the judge admonishes the lawyers to make sure their clients know not to talk to any jurors, even if or anyone in the courtroom or outside of the courtroom. If they walk up and want directions, they're not to talk. And so the attorneys the judges are very strict with that. You are not to talk to anyone during this trial. And so while Mr. Flores is out on bail, he should not be talking to anyone.
Yeah, and I haven't seen him talk to anybody, but it was sort of surprising, that he doesn't have like a separate entrance or.
No, there's not a separate entrance. Because of security concerns, you have to go through the metal detectors.
Yeah, and obviously we have to as well.
Right.
So, and then once I'm in there, it's hard for me to even go up because I know I'm going to have to come back through security. And obviously as journalists, we're not allowed to leave except for during breaks. Is that pretty typical as well?
Yes.
And and in this case, maybe we can put the graphic back up because it's kind of fascinating. We haven't even talked about this yet, but we have this 2-jury system where the cases are being tried simultaneously, but each of the defendants has a separate jury. And so there are 12 jurors and 8 alternates per jury. And so I think that first jury box holds we have the 12 seats in there, but I think it holds maybe 3 additional alternates in the jury box.
They'll put extra chairs.
Yeah, but then in the front row of where it says extra jury, in the front row there are alternates for Paul's jury, and then in the 2nd, 3rd, 4th, and 5th row are like where his jury sits, and there's alternates toward the back of that. So that one half section of the audience is where that extra jury plus the alternates for Paul's jury sit. So does that make it more difficult? Have you ever been involved, or is it common to have 2 juries in one case?
Well, one, it's more efficient that way because it's very expensive to put on a trial of this magnitude. And there's the same witnesses, and it wouldn't make sense to have 2 separate jury trials because that would mean that the witnesses would have to testify twice. So I see why they're doing the 2-jury system. I understand why they're doing the number of alternates with illness, with COVID, with life just happening, family emergencies. If you don't have enough alternate jurors, if something were to go wrong between now and October, you would have to start this whole process.
So that was going to be my question, right? Because so far, while I've been involved in this trial, we're only in day, I think, 3 of testimony or something, right? One of the jurors has already been excused from Ruben's jury, from the father's jury, and they swore in an alternate. So now they're down to 7 alternates. So if they run out of alternates, they do have to start all over again.
Yeah.
Wow. So my other question that keeps popping into my mind is, what happens, they've been instructed not to talk to each other. The opening statements were different. So the DA's opening statement was almost given twice in a sense, right? I mean, it was very similar for both of the defendants. And then each of the defense attorneys responded with their opening statements. The judge said that they have their choice, right? The defense can either do the opening statement at the beginning. They don't have to do one at all. They can do one at the beginning of the trial or right after the prosecutors, or they can wait till the defense. What is typical in that case? Does the defense usually follow with an opening statement, the prosecutor?
Generally, they will follow with an opening statement because the prosecutor has, the prosecutor has the burden of proof beyond a reasonable doubt, and they need to prove that the defendant's guilty. And so the jurors have just heard all this evidence, and they're told that they're to look at the defendants as being innocent because that's Constitution guarantee. Right. They're innocent until proven guilty. And so the jurors just heard the prosecutor giving their opening statement, outlining what they expect the evidence to show, outlining who they expect to call as witnesses, their expert witnesses, any other DNA evidence or whatever evidence they have. So the jurors have heard this evidence and they're like, and they're told, you're not to, this is not evidence. The statements of the attorney is not evidence.
She definitely told him that, yeah.
But how can you not hear this evidence?
Right, and some of the things that are said in the courtroom, I'm wondering if that's part of the, I don't want to call it gamesmanship or something, or like the sort of competition between the attorneys, but one of the things that the defense attorney for Ruben said was before he gave a statement, he said, I was expecting to give a 15-minute opening statement. I didn't expect the prosecution to be trying this case during his opening statement, and now I need more time to respond. So if he says something like that in open court, the jurors are hearing that sort of argument between the two attorneys. How much of that is sort of pre-planned? How much of that is acceptable?
I think it depends on who the defense lawyer, I've had some pretty professional defense lawyers to work with. We can fight among ourselves, because we both have an interest. My interest when I was a prosecutor was to make sure that the defendant that was standing in court, the verdict was guilty, because the evidence in my judgment showed that defendant was guilty, and he needed to answer for what he had done. Now, you can fight with one another, but you can fight professionally. And you can fight in a way where it's not it doesn't take away from the decorum of the courtroom and the decorum of the profession. And I'm a little shocked that the defense lawyer made that kind of a statement.
Yeah, it's kind of interesting. You know, I've been shocked by a couple of things. One of the things that, I mean, I expected this, but I was a little shocked that they went after the sort of character or reputation of Kristin Smart right away in the opening as well, saying, you know, that she was living an at-risk lifestyle and had a history of sort of disappearing for the weekend. Is that odd that they would do that?
Well, in this case, I mean, that's the basis of their defense, is that she's just gone, if I understand correctly, is that she just disappeared, you know, and their client's not responsible for her disappearance. And so it goes back to what I talked about earlier about the credibility, you know, so they're essentially trying to put the victim on trial right now and take away from who's really on trial. And so the prosecutor's job is going to have to be to bring that jury back to, here's why we're here. Here's why we're here. And so what if this is what she has done in the past? But we know that she didn't take off. We know that Mr. Flores killed Kristin Smart.
So following up on my...
Based on the evidence.
Yeah, right. So following up on what I was trying to get to is that, is it possible, or is there a scenario where Ruben's jury could find him guilty of being an accessory and Paul's jury could find him not guilty of murder? And what would happen in that case? Can you be an accessory to murder if there's not a murder?
If you don't have a murder conviction, you're not going to give an accessory.
Okay.
That's my understanding.
Okay. Yeah, I was just wondering what the procedural
part of that is.
And
I did reach out to the DA's office, Dan Dow. I wanted to make sure that's my understanding. Okay. And if I'm wrong, Mr. Dow, please correct me.
Yeah, well, we'll find out. But that keeps popping into my head. I keep wanting to ask somebody about that. So interestingly too, with his two jury system, you know, sometimes one jury's in the courtroom, sometimes they're not. How do they make that decision?
I guess it's based on what's going to be presented, what evidence is being presented, because not all the evidence is relevant to Paul Flores' case versus Ruben Flores. So there's no need to bring that jury in for evidence that they're not going to need to make their decision on the case.
So I've talked a couple of times just in an interview situation with a local defense attorney about his views on some jury selection issues as well. And he has this idea even after his long career. And so I want to ask you, after your long career, you know, do you find that jurors actually do a pretty good job? Do they follow those instructions? Do they take this seriously? Do they pay attention?
Oh, they do. It's amazing. You know, when I was a prosecutor and you put a lot of extra hours in on the weekends after court, because even though you're in trial, your other work doesn't go away.
Right, yeah.
So you still have to do your other work. And you're thinking day and night on, okay, I need to argue this, I need to do this, I need to do that. And you're talking to your investigators on the witnesses and, you know, what I need to prove and, you know, how to present this evidence. And it's always amazing. And I'll never, ever, as long as I live, forget how when you would do a jury trial, or I would do a jury trial, and the verdict would be guilty, and you would stand out waiting for the jurors to come out, or they're waiting for you to come out, because after a defendant's found guilty, then you have to pick a sentencing date, and if the defendant's in custody, then you know they have to be transported. So there's a lot of work that has to take place after the jury has returned with a verdict. And it was always amazing to me that jurors would wait for you to talk to you about the case. And it was fascinating because what you thought was the evidence that was just rock solid of this is why this defendant's guilty.
May not be what they thought.
It wasn't what they thought.
Yeah.
And they would say, oh no, this is what convinced me. And you're like, oh really?
Yeah, interesting.
You know, so it was always interesting. And then you knew that you had a good jury. You knew you had a jury that was paying attention to the evidence, because something that you didn't even think was important, they put a great deal of importance on. And it was something so minor that they used that to convict a defendant.
Well, I just want to thank you so much. This has already been 30 minutes of that.
Okay.
It's been such a fun chance to talk to you, and thanks for providing a little more perspective as well. And hopefully we can check with you again in the future. So,
I'd love to.
And we want to thank you as well for joining us for this special broadcast. And we will be doing this every week. We want to obviously thank my special guest, Mary Wofford, for joining us as well. And we do plan to bring you Facebook Live shows throughout the trials I just mentioned. And so we do hope that you'll join us next time again. And please add your questions. We know this one wasn't live, but it will be on Facebook. add your questions, and we will try to get those answered as completely as we can. And also, you can find all of our coverage for this case on our website, ksby.com. Thanks again, and we will see you next time.